Hello, everyone. Hello and welcome. Thank you very much for joining us today. This is our first webinar in a new series we've just started. My name is Stacey Sinclair. I am the head of Technology and Innovation Group here at Fenwick Elliott. Most of you will already know that Fenwick Elliott is a law firm specializing in construction and energy projects and disputes. And of course, our speakers today are Fenwick Elliott senior partners Simon Tolson and Jeremy Glover, both of which specialize in dispute resolution and of course adjudication, which of course is our topic for the next 30 to 40 minutes, in which they will be covering recent developments in adjudication practice and case law, and practical tips on dealing with the adjudication process in the current climate.
That's great. Thank you very much, Stacey. And thank you all for joining us in what Stacey said was our first lunchtime webinar. And obviously our topic today is adjudication. Both myself and Simon are, as well as working on a number of adjudication cases, we are practicing adjudicators, so we sort of see it from both sides, as it were. And what we wanted to do and what we wanted to look at today was some of the recent decisions from the TCC, just to provide an update on what's happening with adjudication and adjudication enforcement, and also to discuss and look at perhaps a little bit more widely what about adjudication in May 2020? What about adjudication at the time of the COVID-19 pandemic? Have things changed? Will things change? What does the future, what is there for future foretell? But to begin with, getting the basics right, getting the formalities right, and it seems quite remarkable that here we are in 2020 and we're still talking about the importance of getting the basics right, but it still happens. People, particularly referring parties, they sometimes get things wrong, but getting everything right at the start is absolutely crucial. If you get it wrong, the adjudicator is not going to have jurisdiction and you won't have a valid enforceable decision. And there was a case earlier in the year, FlexiDig, where issues arose about whether or not the referral had been served in time. The responding party said that the true date of the notice of adjudication, the document that starts the adjudication process, was 20th of November, because that's when it was sent. But it wasn't disputed that the adjudicator received the reference on the 29th of November. That's a gap of 9 days between the notice and the referral. There should only be a 7-day period. So was the referral out of time? Now, obviously, the adjudicator must have received the referral, and we're talking about actual receipt. So the question was, when did time actually run? And the parties went to the contract, and the contract said that service was deemed to take effect 2 days after the document was sent. So the document was sent on the 22nd of November, received on the 22nd of November. So everything was all well and good. Everything was received in time. So a simple case, a straightforward case, but one that reminds you to look at the contract and get the formalities right. Not so simple, not so straightforward is when insolvency crops up, and many of you will be familiar with the Bresco and the Meadowside cases. And there's something that's slightly more tricky, less straightforward, and the advantage of doing one of these two-person webinars is when they get tricky, when they get straightforward, you can pass the baton on. So I'd like to pass the baton on to Simon to discuss these for you.
Thank you, Jeremy. That's sweet of you. Hello and good afternoon to everyone. Yes, the question of insolvency and adjudicating as an insolvent referring party is, of course, an area that has occupied quite a lot of legal debate over the last 18 months or so, but obviously isn't new to adjudication discussions in the 20 years or so that adjudication's been running. But obviously the seminal case that Jeremy just alluded to was the Bresco decision, initially at first instance of Fraser J, and then before the Court of Appeal at the beginning of 2019. And what that case really did in the kind of current sort of scene of insolvency was to highlight the basic incompatibility that exists in relation to adjudication and insolvency. Because obviously with regard to insolvent companies, they tend to want to achieve things particularly quickly and brashly and at low cost, whilst that's obviously the paradigm of adjudication. it's the finality of the end result that is the concern, and obviously that's a concern of a whole branch of insolvency going back many years, and certainly to the 1986 Companies Act, etc. So that is an important case, as is of course the decision that followed it, or the decisions that followed it, which I'll be discussing briefly in the course of the next few minutes. But let's just have a look at the key case, which is the Balfour, Beatty and Aztek decision decided this year. We are trying, as you probably gathered, to keep topical with current decisions. Now, not unlike the situation in Bresco, where the jurisdictional kind of permissibility of adjudicating was upheld, and you'll remember that was part of the strong judgment of Coulson LJ in the Court of Appeal. But obviously the question of the concept or exercise of futility, as it was termed by Coulson, and recognizing that often, because there isn't essentially a final determination and accounting for claims and cross claims, often that means that essentially it can be an odious endeavour to seek to adjudicate. Now, what happened in Balfour, Beatty and Aztek, it involved a contract at Blackfriars Station. The Aztek project's subcontractor had 3 separate packages and 3 separate contracts, and was basically had commenced one adjudication and was threatening 2 further adjudications. Now, in the sort of backdrop of the project, Aztek's position was it had begun works in 2010, but things obviously didn't run too well for it. By 2014, it went into administration, and then later that year, in October of that year, it actually went into liquidation, but didn't actually, until it got funding organised in 2019, commence a process by which it was going to seek to adjudicate. And that's obviously when issues arose, and particularly when Balfour Beatty sought to effectively injunct that adjudication and the 2 further ones that were being threatened. The case came before Waxman J in the TCC, and he had to basically deal with these 2 key questions in relation to, firstly, was the fact that the company Aztek was insolvent, should that be a basis for effectively preventing it to adjudicate? And secondly, was there an issue in relation to potentially 3 separate adjudications involving a liquidated company, something that made for still greater reason a basis for preventing those from proceeding. Now, I don't want to spend very much time obviously on a quick webinar like this on the insolvency rules, but I think a lot of you will remember that a key rule that was looked at in a case called Bouygues Jensen at the beginning of adjudication, probably 20 years ago, emphasised the importance of Rule 4-90 and insolvency set-off, and how that should and could be operated. That rule was replaced by the insolvency rules update in 2016 by 14-28. But getting to the point, the relevance of that was that the insolvency rules were prayed in aid in relation to this particular application to injunct the contractor from pursuing its adjudications. And the court, through Waxman, reviewed Bresco and the helpful guidance there that adjudication could never reach a position where, if an adjudication couldn't reach a position where the ultimate mutual account between the 2 parties could be concluded because of the interim nature of an adjudication, that was a basis where an injunction might be awarded. And that essentially adjudication by insolvent companies is the exception rather than the rule. And then the further case, which I alluded to a second ago, which he concentrated on, was the Meadow side decision and Hill Street Management, which was an important case where Adam Constable QC, as the judge in that case, made some important findings in relation to really what the exceptions would be, which weren't really spelt out in the Bresco decision, but he took the opportunity to spell out what they might be as essentially a basis on which an adjudication might proceed with an insolvent party. And that was very much on the provision of security, adequate security, and the final determination of a position between the parties in the sense of a closing of account. And the second limb was very importantly the satisfactory provision of security by way of coverage, not just for the adverse effect of a decision which might later be overturned, but the costs that might be involved in the process, and ultimately the process of perhaps overturning that decision. So in Aztek, what Waxman basically had to wrestle with were these concepts and these two issues. He had little difficulty grappling with the three adjudications points on the basis that he took the view that that essentially, in relation to any enforcement, the three cases would essentially be conjoined, and that the court would take steps to ensure that that took place. That's perhaps a little bit of a gloss, but that's essentially what he came to the conclusion on. In relation to the prima facie case about whether the company could adjudicate, he was of the view that an injunction was not appropriate and would not be granted by him because of the exceptions. And he was quite clear in his decision that that there was there needed to be adequate protection. And as the slide says on the screen at the moment, for Balfour Beatty, it had quite a lot of protection in its contract. Ultimately, it had the right to, if the adjudication decision went against it, to bring proceedings within 6 months, and that was a basis on which obviously enforcement might obviously be reversed. But I think the important thing is the level of security which the court, through Waxman's decision, ordered ultimately, and please do look at the judgment, was significant. So the sanction in terms of the exception and the Meadowbank exceptions really kind of gives with one hand, but potentially takes away with the other hand, because it is a very onerous enterprise, certainly for those funding litigation and for administrators and liquidators and litigation funders, because of the level and degree and magnitude of security that might be ordered. So I probably overrun my time on that slide, but
not at all, not at all. And of course, the beauty of it is you just spent a very valuable 5-10 minutes discussing the key implications of sort of Bresco, Meadowside, and the Aztek case. But of course, the Supreme Court on the 23rd and 24th of April heard the appeal in Bresco. So we'll all have to look out in the next few weeks for their judgment, which of course might change the position completely. And obviously, just to prove that this webinar is live, I apologise for ducking out earlier, but I just had a delivery that I had to pick up. The guy knocked on the door 5 minutes after we started. But moving on, I want to talk about the things that adjudicators do. And by this, we mean that the things that we all complain about that adjudicators do, and we all say means their decision can't be enforced. And once again, because it's me, I want to start with something simple and fairly straightforward. Without prejudice documents. Now, we all know you don't put without prejudice documents in court bundles, arbitrators bundles, or the documents supporting adjudication referrals or responding documents, because you don't want the person making the decision to be seeing private confidential information that was put forward while you're negotiating. You don't want the person judging how much money should be paid to be judged by what you really thought was actually due. So really, if without prejudice documentation appears in the adjudication documentation, there could potentially a problem. The decision could be tainted, and there may be a breach of natural justice. But like all these things, it's a question of context. In the Transformed Schools case, which was heard up in Scotland, the adjudicator was one of the issues that the adjudicator had to consider meant that he had to look at some letters that were marked without prejudice. It's one of the core central areas of the adjudication. Now, of course, the losing party complained that by looking at the without prejudice documents, the decision was tainted by bias. But the court took a different view. The adjudicator actually had to look at these documents to make his decision. So what mattered was whether he got the decision right or wrong. And we all know that from an enforcement point of view, whether the adjudicator got the decision right or wrong doesn't matter. So here, he was entitled to look at the without prejudice correspondence. And it's a good example of things not always being as simple and straightforward as they look. But things do get more difficult. Another thing we don't like are adjudicators doing their own thing. We don't want them to be doing that. And we know there's a whole string of cases where adjudicators, for example, if they carry out their own delay analysis to try and get the answer, they can't do that. They won't have jurisdiction. It's a breach of natural justice unless they share that analysis with the parties and give the parties the opportunity to comment on that analysis. But when it becomes slightly more tricky, when there's questions about whether adjudicators are allowed to make use of their own knowledge and expertise, and I think, Simon, that's a bit more of a grey area.
Yeah, no, it is indeed. And as you kind of allude to, there is obviously quite a lot of authority and legal discussion in relation to adjudicators doing their own things, and that goes back certainly to the case of Balfour, Beatty and the Mayor and Burgesses of the London Borough of Lambeth, where the adjudicator, I will spare his name being mentioned, but he basically did his own delay analysis, as you say. And interestingly, but still very relevant to now, what His Honour Judge Humphrey Lloyd decided in that case was that the danger area of adjudicators kind of making good deficiencies that they see in the party's own case is when the adjudicator enters the danger zone. And this case, Platform and ISG, is really touches on the fringes of whether the adjudicator in this case entered that danger zone, or certainly touched the fringes of it, which I think she probably did, but kept sufficiently away in terms of the overall decision to have her decision upheld. But the whole question is linked with natural justice and the perception of fairness and candour and that sort of thing. So this case, Platform, was really about whether the adjudicator had actually done something which was irregular in terms of how she actually processed and made and reached her decision. The facts of the case are probably too unique. It was a payment dispute in relation to the construction of a hotel. There were arguments in relation to termination and rescission, which were played out in the course of arguments. And the question was whether there was a termination account entitlement by ISG on its termination, which it said was valid, or the basis of the account that Platform as the contractor had advanced on the basis of a case in rescission. Ultimately, the adjudicator decided that, in fact, ISG had properly and validly terminated Platform's engagement. But perhaps one would have expected on that basis that ISG's account might have been accepted as being effectively the good one or the right one on the principle of follow through. But in fact, what the adjudicator went on to do was, in fact, determine in terms of the entitlement or the quantum, a basis of entitlement on the part of Platform, which resulted in a sum of money in the hundreds of thousands of pounds being awarded to Platform. And the objection and challenge that was taken by ISG was not obviously in relation to having decided the termination point correctly, which obviously was in their favour, but was with what she then went on to do. And there was kind of shades of Vasco and Cantillon and of ACOM and Stepina and other authorities in relation to what happens when adjudicators make decisions which fall outside what parties may have argued. But in fact, what the judge here, Roger Tahar QC, decided was that what the adjudicator in fact did was reach a decision, not based on the arguments per se that had been run by the parties, but given the various exchanges between the legal teams that were run in the adjudication, she had reached a decision that was still a proper analysis and reasoning of the process. So as that slide says there, from a case called Rowe Brickwork and Waits that Tahar quotes in the judgment that no rule that a judge or arbitrator or adjudicator must decide a case only by accepting the submissions of one party. An adjudicator can reach a decision on a point of importance on the material before him, on the basis of which neither party contended, provided the parties were aware of the relevant material and the issues to which they gave rise, and have been fairly and canvassed before the adjudicator. Now, there was no, the judge was perfectly satisfied that what the adjudicator did here fell within the kind of four corners of that quoted passage from the Rowe brickwork judgment. And the reasoning of the decision is interesting, because one can see and have some sympathy for ISG, perhaps in relation to the arguments that counsel made, which are recited in the judgment. But in the overall result, Tahar was persuaded that that what the adjudicator had done was within those, was permissible, and had not gone outside the jurisdictional bounds.
Yes, so ISG, they actually failed there in their jurisdiction challenge, but they'd actually had a previous hurdle in the same case that they'd actually had to get over before they got to the main part of the judgment, which Simon has been talking about. And that's the question of whether you actually have to pay the adjudicator, even if you're challenging an enforcement. That's another slightly surprising question, but it's also a particularly scary one. You know, sort of my own personal experience when when I was reading a skeleton argument on the eve of enforcement hearing for the first time, to see a party saying, well, actually, you can't bring this hearing to the court. You don't have necessarily standing to bring the challenge to the adjudicator's decision because you paid the adjudicator's fees. And by paying the adjudicator's fees, you affirmed that decision and you can't challenge it. And that was slightly scary, and it worried me. And I looked at some of the judgments, and I looked at some of the judgments that Roger Tahar referred to in the ISG case, and it was right. In theory, paying the adjudicator's fees, you might actually affirm the decision. But it's not quite that simple, happily for me, in my case, and happily for me in the ISG case. What we'd both done, we'd carefully qualified the payment of the adjudicator's fees, and we'd made it clear that we were not affirming the decision, that we wanted to, and we reserved the right to make the challenge. And the judge in the platform case said that was the way to do it. And as a matter of policy, as you can see from the quote, he said that the court shouldn't do anything to discourage payment to an adjudicator of fees for the adjudicator's work. As I said, both myself and Simon are adjudicators, so that's good to hear. But the court, again, will look at the context. They'll look to see what is going on at the time of the payment is made. But of course, adjudicator is going to be very keen in the current climate to achieve payment, as we all are. The country is clearly in a time of recession now, and that looks like it's only going to get worse for the next few months. And that does raise an interesting question when it comes to the stay of the enforcement of an adjudicator's decision. We know that following Wimbledon and Vago, in very limited circumstances, if you can show that the company you're paying the adjudication award to might not be able to repay that award in the future if there's a full litigation of the claim, then there might be a stay on the judgment. And that's something that you can see might become relevant in the current situation. And it's something that, again, Judge Tahar had to consider in the Broseley case. And Simon, I think you had one or two things you wanted to say about this.
Yeah, Roger Tahar's been quite busy actually in the TCC, as one can see with the recent cases. Yeah, this case of Broseley and Prime Assets, I think is actually a pretty important case. Obviously, it's still first instance, but it in many ways takes forward a lot of valuable law and discussion that's come from S&T since the Court of Appeal judgment in that case. Yes, the slide that you have on screen there at the moment, and the passage quoted from Lord Justice Coulson's current edition of his textbook on construction adjudication, that a failure by a defendant to pursue a cross-claim or challenge with diligence may itself bar a successful application for a stay of execution, was well illustrated in this case, because basically there was a considerable amount of delay and a lack of engagement, really, in terms of taking any steps that might be and could have been taken timorously to try and take the dispute somewhere else, or to seek alternative relief through the courts, or in fact to take alternate action by way of adjudication. And Tahar was pretty uncomplimentary in relation to the antics that were taken by Prime Asset in relation to its position. The facts of the case, as I say, are not too unusual. In a lot of adjudication cases, we know generally there's a similar sort of pattern to them. This was a private house refurbishment, large, grand, sort of grade 2 listed property. The defendant, the claimant contractor, was seeking £480,000 by way of an interim application. It was a smash and grab in the sense that there was no payment notice, and the payless notice was served too late. It went to adjudication as soon after the final date for payment was reached. The adjudicator, perhaps not surprisingly, found for the claimant contractor and for the amount that had been claimed, the £480,000 odd. The position that was taken by the defendant was that they accepted that in fact the decision had gone against it in relation to the smash and grab, but they wanted to get a stay of execution in relation to the entire judgment sum. And basically the basis on which it was seeking to do that obviously is a key question. And they made submissions that moved on whether, you know, the defendant could mount a true valued final account adjudication, whether it could actually commence that process and try and effectively get a stay whilst that was actually determined. And basically, as Jeremy alluded to, Roger Tahar spent some time going through the cases like Wimbledon and Vago, and the later decision in Grosvenor and Aegon Aluminium, in basically setting out the sort of things that a party that's trying to prevent an enforcement needs to do by way of getting active evidence, material evidence of the impecuniosity of the other party that's seeking to enforce, that could actually demonstrate a basis that the court could tangibly get its hands on and understand that there was a material or serious risk that the payment might not actually be returnable if ultimately things went the other way in a final account, final true value determination. So the whole question about the availability and lack of diligence on the part of the defendant in terms of acting with diligence in getting Part 7 proceedings together. I mean, the hearing was one of the COVID hearings. It took place in April, but the events in relation to when they should have taken action, if they were going to take it, was around September, October of 2019. So that combined with this sort of unconvincing argument about the improbability of the claimant being able to repay the judgment were key issues which come out of the case. And
I mean, that's right, Simon. And I think, you know, it's almost like because of their delay, they missed the opportunity to run the argument that because of the economic situation had changed because of the C-19 pandemic. So I think that the question of a stay is one of those issues when you talk about adjudicating in the time of COVID-19. It's something that maybe in the next 3 or 4 months you're going to see more of in the TCC, as parties might say, well, look, everybody's economic position has changed because of this pandemic. So it won't be interesting to see how that plays out. But when it comes to actual whether or not you can adjudicate in the time of sort of COVID-19 or not, I think most people, most of the attendees on this webinar will have seen reports of the Milchrist case where it was said, well, actually an injunction was applied for that, well, we can't have this adjudication because of the lockdown means it's not fair and you can't actually carry out the proper fair adjudication process. And the TCC were having none of that. I mean, TCC were effectively saying adjudication business should try and continue by and large as much as possible. You've got to be sensible, you've got to be reasonable, you've got to take account of the situation you find yourself in. Obviously the lockdown position has changed from what it was in 8 weeks' time, but basically there's no bar on adjudicating. And it's very much then there's going to be an onus on the adjudicators themselves. And obviously they always have to take charge of the process, but you have to consider the timetable. What's fair in all the circumstances? Is it really going to take longer? Well, quite often it will. If you've got your lawyer, your expert, your client, and you're all in different places, it may well take longer to put together a response. Of course, you've got to look at whether parties actually trying to take advantage of the situation and trying to elongate the timetable unnecessarily, but that's for the adjudicator to judge. But a very interesting thing, of course, is when it comes to the site visit. From an adjudicator's point of view, well, there might be health and safety considerations. There might be other considerations. And I don't know, Simon, about what you think. I mean, if you're going to actually be asked to go on a site visit as an adjudicator, would you do it at the moment? What would you be taking into account?
Yeah, I mean, I think if you asked that question about 3 weeks ago and you ask it today, you probably get a slightly different answer. I think subject to all of the guidance and social distancing, the 2 meter rule, where you can, etc. I think it might be a situation where a site visit, if it's simply to look at the building fabric and access can be arranged, but with parties, representatives being present, obviously appropriate steps would need to be taken. But I mean, as we all know in the real world, it is still pretty rare for adjudicators to go on site that often, unless you're dealing with a building defects case, and special arrangements or electronic, alternatives, videos, drones, if it's something you can fly over, are means of accommodating it. So I think it's likely to be more of a can-do mentality by the majority of experienced adjudicators.
Yeah, I think I agree with you too. And also, when you come to the idea of there's no bar on people holding sort of virtual hearings. I mean, we know that the TCC are holding virtual hearings or telephone hearings. So we know that there shouldn't be any different for the adjudicators. And so looking forward, adjudication in May 2020. I mean, it's clear that all the adjudication providers they're thinking quite hard about how they can make adjudicating more proportionate. TEXA, the CIC, RICS, they've all got their sort of low value dispute claims. They've all got little shorter periods. They're looking to see how they can make the process work better for all parties. And I think we're going to see more of that when it comes to 2020. And another interesting document that's come out is the CIC COVID-19 contractual best practice guidance. Yeah. There's some interesting words there, and it says in particular parties are encouraged to act fairly and reasonably when administering contracts and agreeing variations, especially given the impact of COVID-19. And before I hand back to Stacey for the audience questions, I've got another question for you, Simon. I mean, if you're an adjudicator and you're making a decision, to what extent would you be influenced if someone said, well, I'm sorry, but the responding party hasn't acted in accordance with the CIC best practice. They didn't act fairly and reasonably, and that's why I've brought one of the reasons why I'm entitled to make this claim and succeed in my claim in adjudication. Do you think the CIC guidance will have any impact in you as an adjudicator?
I mean, I think it's guidance at the end of the day. And when I was reading them again yesterday, and I think I'm slightly cynical about the effect of guidance, because guidance is not law and it's not delegated legislation as such. But yeah, I think permeating through all of our minds as adjudicators and arbitrators, and I'm sure judges, is what what the impact of the situation is, and that will be taken into account up to a point. In relation to how conduct is perceived and whether it's discrepant or not. I think the encouragement not to get too bogged down in disputes that the CIC is advocating in its guidance, I think is sensible. But I don't think that line is going to be sustained for very long. I think the anecdotal evidence, got a real life person at the door at the moment knocking, so if you're hearing that, that's someone come in, is that the volume of adjudications has actually dropped slightly over the last 6 or 8 weeks. But I know from TEXA, who I'm closely involved with, that there's been an uptick in relation to adjudications. So we'll have to see. I think it's too early to kind of form a view on the data, Jeremy.
Okay, Stacey, I mean, are there any other questions that have come in?
Thank you, Jeremy and Simon. Yes, we've had an overwhelming number of questions coming in from the audience, which is fantastic to see. So thank you, everyone. I can see we're, of course, not going to be able to address all of them in the time. However, a number of them are relating to the state and uptake of adjudication proceedings and indeed hearings over the past few months. So perhaps we can start with that. I know you've just touched on it briefly now, but have you seen, can you expand on any recent increases or decreases in the number of adjudications and in particular hearings over the course of the past 2 months?
I'll let Jeremy speak, answer that in a moment, but I think a lot of people have over the last 7 or 8 weeks just initially obviously had to take on mostly what I would say is shock, and then adapting to circumstances, having to deal with staff issues and huge issues in their businesses. And I think it's probably only in the last 3 or 4 weeks that those disputes that weren't sort of work in progress and about to go at the time that we were locked down on the 23rd of March, whenever it was, I think most of the other disputes are probably, because we can see it from our own office, have begun to pick up over the last 2 or 3 weeks. You know, those that can be made oven ready. But I think if you've got problems with access to documents in offices and so forth, and I know speaking to a lot of parties, that is a bit of an issue, particularly where those aren't always electronically saved and stored. You've got to get someone to get down to the office to do some things with documents to make them available. Jeremy.
I suppose following on from that, one question someone else had is, will adjudicators accept only electronic submissions at the moment?
Sure. That's an interesting one. I mean, most adjudications that I've been involved in over the last 12 to 18 months, all the documentation has been exchanged electronically in any event. Sometimes parties have sent me the documents, and sometimes the adjudicator has asked for documents to be sent, a hard copy to be sent to follow the electronic submission that we've been made. You can see why people might not want to receive documents at the current position, but my gut feel is that adjudicators and parties anyway are already in a position where they can probably make submissions electronically. And so if an adjudicator said that, I wouldn't be too surprised. If there are 1 or 2 key documents that maybe they were drawings or programs or plans that are going to be A1 or bigger, then I think that you'd probably still want an adjudicator to have a hard copy of those.
Yeah, I think adjudicators also have to be match fit themselves. So I mean, any competent adjudicator really needs to be set up with business machinery like printers and so forth, where they can print essential documents. But I agree with you, Jeremy. I think for the last few years, portals have been used extensively, and hard copy sets as a luxury in A5s on the basis that that's nice to have. But yeah, I think the courts would take pretty short thrift on the basis the judges are dealing with quite significant cases, including the Court of Appeal, on electronic only bundles, and I would expect adjudicators should likewise try and work in the same environment.
Okay, let's move on to another question. I think time permitting, perhaps one more. Do you think adjudicators will be sympathetic to contractors who have chosen to pull off site temporarily at the start of lockdown and now are in dispute with employers over it?
Good question.
The typical lawyer cop-out answer is it depends on what the contract says. You know, obviously you are going to be sympathetic to the situation. And you're going to be sympathetic to, you know, it's an unprecedented situation, and people are going to react in a number of different ways. And, you know, hand on heart, am I going to be swayed by that? Well, it's something I cannot take out, and, you know, I cannot avoid and ignore entirely. Ultimately, though, every adjudicator has to follow what the contract says and what are the contractual legal obligations, what are the contractual legal entitlements of the parties, and that's what you should be looking at as an adjudicator when you make your decision.
But I think some of that contractual best practice of the CIC, I suspect we'll see that creeping in terms of submissions, you know, reserving their strict contractual rights, but trying to effectively plead clemency in some sort of way around the kind of main quality of looking after the safety and well-being of their staff and their subcontractors and their suppliers. And it's, as you say, Jeremy, it's all context, and of course it's down to what the actual contract says as well.
Yeah, I mean, but you mean, Simon, you were talking about the difficulty of getting hold of records, or difficulty perhaps sometime of maintaining records. Now that's a different issue, and it might be then that you might be thinking, well, I can see why in the current situation it wasn't possible to produce the records that I would necessarily expect, and therefore if you're balancing the situation, then that might influence you. I mean, it's an interesting one. It's sort of, you obviously got to go for what the strict legal contractual arguments are, and then you're still weighing the evidence that people are able to put forward in front of you.
I think as adjudicators,
no, I think looking at the time, we're gonna have to end on that. I'm very sorry we've not been able to address everyone's questions in the time allowed. However, thank you very much for submitting them. And please do feel free to email either myself or Jeremy or Simon. And we should have, you will have seen the email addresses a moment ago. But before we leave, I wanted to say thank you very much, Jeremy and Simon, for such a detailed and informative session. We've been running through the issues over the past couple of months, and I know all of our audience and seeing all the questions coming in have been deeply appreciative of your thoughts on that. And a huge thank you to everyone indeed for joining us around the world today. It's been wonderful to see so many of you on the call. A number of questions regarding a copy of the slides I can see that you're interested in having a copy of. We'll make these available on our website shortly, or we'll circulate them via email to the attendees. Also, we do hope you can join us next week. Same time, same place, 12 noon on Thursday, the 21st of May, where our Fenwick Elliott partners, John Miller and David Bebb, will be discussing what the impact of COVID-19 is having on construction contracts, as well as the practical steps parties need to consider moving forward. I've seen a number of questions coming in today specifically in relation to this. So please do register for next week's webinar, and I'm sure these questions will be addressed and answered there. You can register for that webinar. Look out for a further email, and indeed on our events webinar page on the website. So on behalf of Fenwick Elliott, we do hope you are keeping safe and well wherever you might be today. And thank you again very much for joining us. We look forward to seeing you either virtually or socially distanced very soon. And thank you everyone again, and take care.
Thank you.
Thank you.